All right, Senator Kyokohole, live stream starting in 5, 4, 3, 2, 1.
Okay, good afternoon, everyone. We are convening the Hawaii State Senate Health Committee's Wednesday, March 17th, 1 p.m. agenda. I'm Senator Jarrett Kyohokalole, chair of the committee. I'm joined by my fellow committee members, Vice Chair Senator Rosalind Baker, Senator Joy San Buenaventura, and we also on the committee have Senators Kurt Favela and Sharon Moriwaki. As you know, this is a YouTube, Zoom and YouTube live stream event. In the unlikely event that we must abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Monday, March 22nd at 1 p.m. and public notice will be posted on the legislature's website. We have a lot of testimony today, including, I'm happy to report many individual testifiers who will participate on the Zoom conference today. So with that said, I would like to note for everyone joining us to testify that all audio will be muted and video disabled until it is your turn. We are instituting a 2-minute time limit per testifier. You know, in one of the measures, the Senate version of one of the measures, we had a lot of testimony and we had to defer decision-making. I do not want to do that today. So when you reach your 2-minute time limit, I will be forced to move on. So we have received your written testimony. It has been provided to the members. So in the interest of time, I'd like to encourage you to stand on those remarks. If you would like to augment or clarify your written testimony, please do so within the 2 minutes so that we can keep this proceeding moving and vote on these measures at the end of the agenda before we run out of time. If there are temporary technical glitches during your turn, we may move on, but we will try to circle back to you to give everybody the opportunity to testify. Okay, so we're gonna move to the first measure on the agenda, HB 723 HD1, relating to pandemic response. This authorizes use of funds appropriated from the Emergency and Budget Reserve Fund, from the amounts received from the state, by the state from the Coronavirus Aid, Relief, and Economic Security Act for the purchase and distribution of PPE and industrial hygiene products to state departments and attached agencies. First testifier we have for HIEMA, Luke Myers in support.
Good afternoon, Chair, Vice Chair. My name is Luke Myers. I'm the Administrator of the Hawaii Emergency Management Agency. HIEMA stands on a written testimony in support of House Bill 723 and are available for discussion as necessary. Thank you, sir.
Thank you very much. Hawaii Department of Education, Randall Tanaka in support.
Yes, aloha, Chair, Vice Chair, members of the committee. We stand by our testimony and here to answer any questions that you may have. Aloha.
Thank you. Department of Health in support.
Good afternoon, Chair, members of the committee. Lauren Kim for the Department of Health. We stand on our testimony in support and are available for questions. Thank you.
Thank you very much. That's all the testimony we've received from individuals who indicated they would be present. Is there anyone else on the conference who would like to testify on this measure, HB 723? Okay, seeing none, I'd like to indicate, indicate the supportive written testimony from the Department of Public Safety, the State Procurement Office, the HHSC, the Hawaii Office of Community Services, and the Hawaii Primary Care Association. Again, written remarks all in support. That's all the testimony we've received on this measure. Members, any questions? Okay, we're gonna move to the next measure on the agenda, HB 302 HD1, relating to advanced practice registered nurses. This authorizes APRNs to certify whether a person is totally disabled under the income tax code, and authorizes APRNs with psychiatric specializations to make capacity determinations. First up, we have the Department of Taxation offering comments.
Department of Tax will stand on its written testimony offering comments. Thank you.
Thank you very much. And for the Hawaii State Center for Nursing, Laura Reichart in support.
Good afternoon, Chair. Thank you for the opportunity to provide testimony and support. I want to highlight two areas of the testimony from the Hawaii State Center for Nursing. The first is our request to change APRN with psychiatric specialization to APRN in general. The scope of practice is restricted by the certification that an APRN holds, and they can only have that certification based on their education and training. So only those APRNs who have the capacity, the education and training competency and certification would be able to do this by the Nurse Practice Act, which is pre-existing. Secondly, I ask for your consideration to include authorization for APRNs to refer to home health services and to certify home health services. This was an allowance that was made from the CARES Act. The Federal CARES Act passed last year. And currently there is a waiver from OCA, but it is not in statute. And we would have to go through administrative rules to change that, to make that allowance permanent. So I ask for your consideration to enable that authorization for APRNs through statute so that the people, particularly on neighbor islands, who are being referred to home health services by their APRNs can continue receiving those services. And I'm available for questions. Thank you.
Okay, that's all the testimony we've received from individuals who indicated they would be present on the conference. Did I miss anyone? Okay, seeing none, I'd like to note the written testimony in support from the DCCA Board of Nursing, the Hawaii American Nurses Association in support, Hawaii Psychological Association in support, the Hawaii Substance Abuse Coalition, the National Association of Social Workers Hawaii, the Queen's Health Systems, all in support, and individual testimony in support from Yvonne Gisi, Wailua Brandman, Kathleen Yokouchi, Susan Lee, comments from Jackie Mishler, and late testimony in support from the Hawaii Association of Professional Nurses. That's all the testimony we've received. Members, are there any questions? Okay, seeing none, I have a question for Ms. Reichart.
Yes.
So the CARES Act authorization you noted, there is an alternative to statute. It's administrative rules. You know, is someone actually? I don't know if this is for you. This might be for the Department of Health. How long would it take in terms of timeline to amend the rules in order to allow this?
I would defer to the Department.
Yeah, Lauren, maybe this is actually for you.
Normal rulemaking takes anywhere from 1.5 to 3 years. We can move a little quicker if we have interim rulemaking authority, but it is by nature a deliberative process and does take time for legal review, public hearing, and various approvals as to form. So it's not the quickest process in the world, though we do support the intent of APRNs practicing at the top of their license.
Okay. Okay, great. Thank you very much. Members, any further questions? Senator Moriwaki.
Just a follow up to Lauren. So if it is in statute, does that circumvent, or will that be a problem if you have it in rule?
No, not to my knowledge. Statute always supersedes rulemaking. Our rules can never exceed the statutory and legal framework set by statute. So if you wish to enact this measure through statute, it would have the force of law on it upon enactment, and we would have to catch up on the back end with our administrative rules for it to parallel what's in statute. But
So
for all practical purposes, it would be in effect because it has the force of law.
So there's not a rule on this at this time.
Not to my knowledge. I've discussed this with Ms. Reichart and the variety and number of rules that any department has in queue at any one point. It is not a glamorous task at updating administrative rules. It's a lot of trudging through many different scenarios, but it is an important process. And we certainly do not want in the executive branch to leave that authority on the table. But if there is an opportunity to do some good in the community and bring healthcare to where it's necessary and needed sooner rather than later, then again, although we don't like leaving rulemaking authority on the table in the executive branch, but there are opportunities where immediate amendment or immediate change through statute serves the greater public good.
Okay, thank you. Thank you, Chair.
Okay, if there are no other questions, we're going to move to the next item on the agenda, which is HB 987 HD1 related to Hearing and Vision Program. This amends the Hearing and Vision Program statute to increase the early identification of children with hearing or vision loss by establishing consistent protocols for hearing and vision screening and follow-up, screener training, and data collection for quality improvement. First, we have the Department of Health, Health Resources Administration in support.
Aloha, I am Dr. Patricia Hugh, Chief of the Children with Special Health Needs Branch. The department stands on its written testimony in strong support. Thank you. I will be available for questions.
Thank you very much. Next, we have Nikki Kipo'o in support.
Aloha, Nikki Kipo'o. I'm a hearing mom to a deaf child. I also am a parent advocate. I stand in full support of this bill and here if there's any questions.
Thank you very much. That's all the testimony we've received from individuals who noted that they would be present in the conference. Is there anyone else who would like to testify on this measure? Okay, so for the record, I'd like to note supportive testimony from the Disability and Communication Access Board, the Executive Office on Early Learning in support, Early Childhood Action Strategy in support, the Hawaii Speech, Language, and Hearing Association in support, the State Council on Developmental Disabilities in support, and also Darcy Singlehurst and Stephen Laracuente in support. That's all the testimony we've received on this measure. Members, are there any questions? Okay, seeing none, we'll move to the next measure, HB 986 HD1. This is relating to newborn hearing screening. This requires diagnostic audiologic evaluation results of newborn hearing screening evaluations or infants whose hearing status changes to be provided to the Department of Health. First up again, we have the Department of Health in support.
Aloha, I am Dr. Patricia Hugh, Chief of the Children with Special Health Needs Branch. The department is in strong support of this measure. I would like to clarify that under the current Hawaii revised statute, it is already mandated that the newborn hearing screening program receive hearing screening results from birthing facilities. If an infant fails an initial hearing screen, the next step is a comprehensive diagnostic evaluation. This bill is to mandate that the department always also receives diagnostic evaluation results for infants who do not pass hearing screening or are diagnosed as deaf or hard of hearing. This will ensure that the infant receives timely follow-up testing and/or early intervention services. Thank you. I will be available for questions.
Thank you very much. Next, we have Ms. Kipo'o in support.
Hi, aloha. I did want to mention that I also serve as a parent advocate on the newborn hearing screening panel, and our loss to follow-up is a very significant amount for the state of Hawaii. We have a ratio of, I believe, a 1 to 4 of deaf children that are born to hearing families. And I would say majority of them aren't aware of their child having a hearing loss or is giving a lot of mixed information from their audiologist or their provider. My son wasn't diagnosed for probably about 6 to 8 months after he was born before we had a concrete diagnosis of his deafness. So I think it's a critical, although it's there, it doesn't happen efficiently. And a lot of our parents are being lost in that gap. Thank you.
Thank you very much. That's all the testimony we've received from individuals who indicated they would be present. Is there anyone else on the conference who would like to testify on this measure? Okay, seeing none, I'd like to note the written testimony in support from the Disability and Communication Access Board, Executive Office on Early Learning, Early Childhood Action Strategy, Hawaii Speech, Language, and Hearing Association, the State Council on Developmental Disabilities, Darcy Singlehurst, and Stephen Laracuente. That's all the testimony we've received. Members, are there any questions? Okay, seeing none, we're going to move to HB 1096 HD2 relating to parentage. This requires the Department of Health to convene a task force to recommend amendments, to the Hawaii revised statutes to update existing parentage laws and reflect outdated cis-heteronormative concepts of families, parenthood, and parental rights. First, we have in support the Department of Health.
Good afternoon, Chair, members of the committee. Department supports this measure. We think it is an important public policy discussion about fairness and equity. And we look forward to convening a working group and submitting recommendations so that all kinds of families have equitable access and opportunities to be responsible, loving families. Thank you.
Thank you very much. Next up in support, the ACLU of Hawaii.
Chair, they're not available.
Okay, next up, I think, is it Affirm Hawaii? Sarah Hamid in support.
Aloha Chair, Vice Chair. My name is Sarah Mikal Hamid with Affirm Hawaii, and we stand today in support of HB 1096 HD2. You have our testimony before you, but we offer comments. While we support the intent of a task force, we do ask the committee to adopt a version of this bill that would amend the unconstitutional restriction on the equal rights of LGBTQ parents and people. In its original form, HB 1096 opened the voluntary establishment of parenthood to all partners of a birthing person, regardless of their gender identity or biological contribution to the child. The bill also adopted gender-inclusive language such as parentage, in addition to paternity, in recognition of the validity of all birthing people and families. We understand that this issue is urgent, and that's why we ask for the original language to be reinstated. Thanks so much.
Thank you very much. Testifying for the Associated Students of the University of Hawaii, Donovan Albano.
Aloha Chair Kehokalole, Vice Chair Baker, and members of the Senate Committee on Health. My name is Donovan Kamakani Albano, and I'm the president of the Associated Students of the University of Hawaii on Manoa, the undergraduate student government that represents over 10,000 full-time classified undergraduates. ASUH stands on our written testimony in support of HB 1096, namely in its original form, and urge you to pass a measure that effectively eliminates discrimination against LGBTQIA+ parents. Just like Sarah mentioned, while we support the intent of a task force, we ask the committee to adopt a version of the bill that would amend the unconstitutional restrictions on the equal rights of LGBTQIA+ people in the Uniform Parentage Act. You have our testimony that shows our unanimous passing of a resolution in support of the amendment of the Uniform Parentage Act, where we view the UPA in its current form as explicitly privileging cisgender heterosexual individuals and discriminating against the LGBTQIA+ community. And we believe and recognize the rejection of non-binarist cis-heteronormative sex and gender being intrinsically tied to colonialism. Many folks, including myself, believe that discrimination against and the attempted erasure of queer, non-binary, Mahu LGBTQ+ folks are deeply rooted in colonialism, and a delay in direct action would prolong the significant financial and emotional burdens that are forced upon female, non-binary, and queer partners. Speaking as an individual, a queer male myself, I recognize and acknowledge the privilege that I have, and parents of any gender identity should be able to establish their valid and legal right to parent their children. I also want to recognize that even in Hawaii, ancestral knowledge of queer kinship has existed for centuries and continues to exist, and legislators have a long overdue responsibility to take active roles in queer liberation and anti-imperial transnational feminism. Thank you so much for the opportunity to testify today.
Thank you very much. Next, Hawaii Women Lawyers in support.
Good afternoon, Chair Kehokalole, Vice Chair, and members. Mihoko Ito on behalf of the Hawaii Women Lawyers. I just wanted to note that Hawaii Women Lawyers filed testimony in support, but I also submitted individual testimony and would like to speak in my personal capacity. I do feel the pain and frustration of many of the other family testifiers because I was in their similar shoes just a few years ago. In my case, due to health issues, we decided to use a surrogate to give birth to our twins. So I was a non-gestational parent, and I felt the same concerns about how I would be legally recognized as the mother of my children. In going through that process, I did research how other states handled the legal process of parentage. And what I discovered that was key to the entire process was the ability to get a pre-birth order. And what that means is that your rights as a parent are settled and established prior to birth, and you have a court order that you can show healthcare providers and anyone else who needs to know that you are the legal parents of the child about to be born. In my case, because Hawaii didn't have these specific processes in place, we chose to use a surrogate in California, where the pre-birth order procedure already exists. So there are updates to the Uniform Parentage Act that we feel would help accomplish the same procedure in Hawaii, but they're pretty substantial updates. And for that reason, I support a task force moving forward. And finally, I'd just like to say I'm happy to help try to resolve this issue because I personally would love to see a path forward for this process so that all families are able to have the security of knowing that if they're the intended parents of a child, the rights are clear before the child is born. Thanks for the opportunity to testify.
Thank you very much. Next, we have the LGBT caucus of the Democratic Party of Hawaii, Mr. Goliu.
Yes. Good afternoon. Michael Goliu on behalf of the LGBT caucus of the Democratic Party of Hawaii. We stand in full support of the bill before you, as well as the amendments offered by our firm to bring the original bill into this one as well. What we'd like to focus the rest of our time on is the amendments we've asked for the task force. Currently, under the current makeup of the task force, there's no assurances that there will be a gay male couple with a non-binary couple, a lesbian couple on the task force to be able to share their experiences and also the needs and their experiences to making sure they're a part of the decision-making process that comes out of this task force. And as we've seen before in past and other task force, if we're not there to voice our concerns, we don't get what we need out of the task force. And so we hope that you will encourage this because we need to have one person or one group to say they speak on behalf of the entire LGBTQIA plus community is not possible. But we believe with these additions that we'll have a broader, more in-depth discussion and be able to help other couples as they move forward. So on that, like I said in my testimony, the LGBT caucuses will be available to assist should you make these amendments to make sure that we locate couples, parents that to sit on the task force. So thank you, and thank you for hearing this bill, and we ask that you move it forward. Mahalo.
Thank you very much. Next, we have the Maui Equality Coalition in support. Valerie Clark.
Chair, she is not available.
Okay, Monique DeSimone in support.
Thank you, Chair, Vice Chair. I stand on my written testimony, but do have some additions. It's been brought to my attention that concerns were raised regarding the term cis heteronormativity. This term is widely accepted within academia, the social science literature, and in the English language. Cisgender references a person whose gender identity corresponds with the sex the person was assigned at birth. Heteronormativity is based on the attitude that heterosexuality is the only normal and natural expression of sexuality. Cisgender and heteronormative together refers to the culture that only views and normalizes opposite cisgender relationships. To suggest a task force or to outright reject this bill due to use of a widely accepted term is to perpetuate cis heteronormativity as the only acceptable viewpoint. This bill is needed now, not later. It is needed for queer families that are birthing tonight. It was needed for my family when our son was born in June 2020. To hyper-focus and get hung up on one term is to avoid and placate the necessary change that this bill is requesting. As a non-gestational parent to my child, the focus on language and biology was a dominant experience during our pregnancy. We had healthcare providers asking who the father is, father or mother being a term more often referred to as DNA than the loving role one fulfills as a parent. What folks do not see is the equal love within our household. They don't see all the times I soothed my acid reflux-ridden newborn, They don't see how often I feed, bathe, and care for him. I'm his primary caregiver, yet there are people who still won't recognize me as his mother. In an article by Civil Beat that recently featured this bill and my family, Facebook comments flooded the internet that read, and I quote, "Teaching them lies from birth, tisk tisk," end quote. And I quote, "They're not both parents. One of the parents is male," end quote. Failure to approve this bill is supporting the rhetoric and cis heteronormative ideology that my family isn't real, and therefore does not deserve the same recognition and rights. Thank you for the opportunity to testify.
Again, we have a number of testifiers. I really don't want to run out of, I respect everyone's desire to testify on this measure, but we are under time constraints and I do not want to have to defer decision-making on this entire agenda. So if you can please limit your remarks to 2 minutes, I would deeply appreciate it. Ashley Galatkak in support.
Aloha, Chair, Vice Chair, and members of the Senate Committee. My name is Ashley Galatkak, and I strongly support HB 1096 in its original form. I stand by my written testimony and would like to provide additional comments. 1096 would update the law to end cis heteronormativity. See, I can even stumble upon the words. Even if you haven't heard of the term, you know it, because unfortunately, cis heteronormativity explains why there is still a gendered wage gap, women significantly making less than men, why gay marriage was only legalized 6 years ago, why openly gay people are discriminated against and are excluded from leadership roles in high positions in public and the private sector, why trans people are far more likely to experience violence and hate crimes, and why queer parents in 2021 still have to fight for their rights to be a parent. There is a history of open and normalized queerness in pre-colonial society and in Hawaii. Yet there's an imposition of missionary ideals that have been defined as traditional family views and values. I ask you to refer to Dr. Hioli Jamaica Sorio's testimony, but I would like to say that there are cis heteropatriarchal laws that impact our lives today. That's why this voluntary parentage right is only afforded to male identified partners of birthing people. Female, non-binary, and queer partners are excluded from this same right. HB 1096 would recognize couples like my partner and I, 2 women who were born and raised here in Hawaii. We dream to raise our future children here, where our families are, and there's no place we would rather be. I urge you to pass this measure that effectively eliminates the discrimination against LGBTQ parents and honor the sacredness and beauty of their families. Thank you.
Thank you very much. Next we have Mihoko already went. Alexandra Balgos.
Aloha, Chair, Vice Chair, and members of the committee. My name is Alexandra Balgos. I'm a non-binary individual, and my partner is non-binary. We're unmarried, and we don't have any intention of marrying. And I don't look forward to having to navigate the process for when we decide to have a child. I don't have upwards of $20,000 to accommodate the legal process associated with having my partner recognized as my co-parent, as they don't subscribe to like the male gender. It's unacceptable that parents who don't fit the quote unquote traditional family ideal are forced into a lengthy, complicated, and expensive process of obtaining an adoption decree in order to establish parental rights to their child. So I'd like to just remind the committee that LGBTQ justice was not achieved with just marriage equality. There's a lifetime of work that still must be done to ensure equity for the queer community. The law as it's written now is antiquated, flawed, and sends a message to the entire LGBT community that the state doesn't believe in our right to parenthood. So we shouldn't have to pander to the state for our rights to our children to be recognized. And while I do support the intent of the task force, I do believe that the bill as it is originally written would suit our needs in the immediate. Raming Salamat for this opportunity to testify and strong support for this measure.
Thank you very much. Next, we have Jim Hochberg in opposition.
Not available.
Okay. Jamaica Osorio in support.
Also not available, Chair.
Ihilani Lasconia in support.
Aloha, Chair Kehokolole, Vice Chair Baker, and members of the Senate Committee on Health. Thank you for the opportunity to present testimony on House Bill 1096 relating to parentage, also known as the LGBTQ+ Family Justice Bill. My name is Ihilani Lasconia, and I support this measure in its original form and urge you folks to pass this measure that effectively and efficiently eliminates discrimination against LGBTQ+ parents. While I support the task force created through this bill, I strongly ask the committee to adopt a version of the bill that would amend the unconstitutional restriction on the rights, equal rights of LGBTQ+ people and our families. In its original form, HB 1096 opened the voluntary establishment of parenthood to all partners of birthing persons, regardless of their gender identity or biological contribution to the child. The bill also adopted gender-inclusive language, such as parentage, in addition to paternity, in recognition of the validity of all birthing people and families. Although it is my deepest hope that this task force can meet the demands of the bill, I also fully recognize that these changes in rights can be granted right here and today through the supporting of the bill in its original form. Changing gears a little bit, as a Kanaka Maoli, we are faced with overwhelming disparities in regards to health, education, and housing. For queer Native Hawaiians, we are faced with all of these struggles in addition to the stress and harm of not being able to claim our own ohana. As a Native Hawaiian, I know the pain of being severed from my aina and my language. But as a queer Kanaka who hopes to be an amazing mother one day, please do not allow me to feel the pain of being severed from my own keiki. I cannot be the parent that I dream of becoming without HB 1096. So many of us know the violent history of the erasure being done against Native Hawaiians in regards to land, language, and culture because of colonization. What is perhaps less apparent is that because of colonization, queerphobia has erased the histories of Mahu and LGBTQ+ Kanaka as well. Please stop allowing the state to erase queer Kanaka from our mo'okuahau or genealogies twice. Mahalo for your dedication to LGBTQ+ rights in Hawaii and the opportunity to testify on this bill.
Thank you very much. Next, we have Carol E. Lockwood in support.
Good afternoon, Chair, Vice Chair, members of the committee. You have my written testimony, but I also wanted to just testify in person today to reiterate my strong support for the creation of the task force proposed by HB 1096. But I really want to urge the committee to take advantage of this opportunity that the task force represents to undertake a more comprehensive review of the UPA. Many of the inequities in the UPA as they affect LGBTQ+ families also affect heteronormative families that are dealing with infertility and result from the fact that the UPA is outdated. It does not accommodate the different ways families are created these days with the assistance of donation, donor insemination, embryo transfers, and the use of gestational surrogates. For example, as noted in the original iteration of HB 1096, an unmarried gestational partner cannot name her same-sex female partner on a child's initial birth certificate. That is, however, also the case when you're dealing with a married gestational carrier who cannot list the name of the intended father, the genetic father of the child on the birth certificate because her husband is the presumed legal father of the child at birth. Likewise, same-sex male couples cannot be listed on the original birth certificate when they use a gestational carrier. Other examples include a woman who's married but has been separated from her husband for years or even decades, cannot name her child's biological father on the birth certificate, or of course, in the case it's a female partner, her female partner, because her estranged married spouse is deemed at birth the second legal parent of her child. So there are a lot of different situations addressing not only LGBTQ+ families, but also heteronormative families dealing with infertility that are simply not addressed or accommodated by the UPA as currently drafted. There is no need for us to reinvent the wheel in this regard. As Mihoko Ito mentioned earlier, there are ample examples in other states, and the American Bar Association has a model act amending the UPA that is available. And in fact, there is an effort already underway here to come up with an amended version of the UPA.
Lockwood,
So
thank you very much.
Okay, thank you.
Very much. That's all the testimony that we've received on this measure from individuals who indicated they would be present. Is there anyone else on the conference who would like to testify? Okay, seeing none, I'd like to note for the record the submitted written testimony of Young-hee Overly in support of the AAUW of Hawaii, the Hawaii Women's Coalition in support, Nikki Ann Yee, Ma'i Movement Hawaii in support, Planned Parenthood Votes Northwest and Hawaii in support, Yulia Muschenko in opposition, Melanie Lander in support. The following individuals also submitting testimony in support: Kristen Young, Piper Kublik, Nadine Newlight, Eileen McKee, Joe Wilson, Marjorie Eno, Cedar Wilson, Anna Mackey, Calais DeSimone, Thaddeus Pham, Mikey Ozoa Aglugub, Tammy Whitney, Jacob Shearer, Rebecca Goldschmidt, Nicholas Chagnon, Kalai Joy, Patricia Billick, Joanne Adams, Olan Fisher, Scott Fisher, Alani Bakal, Annie Doe, Cheryl Burkhart, Kuri Lee, Melissa Tomlinson, Valerie Atkinson, Nanea Lowe, Rosalind Calderon, Jen Jenkins, Maria Denzer, Shadini Raidu, James Doran, Jade Chihara, Miley Wong, Crystal Richmond, Jenna McLaughlin, Hannah Malia May, and late testimony from the Attorney General's office offering comments. Also submitting late testimony, Healthy Mothers, Healthy Babies in support. The LGBTQ plus Rainbow Alliance in support. Rainbow Family 808. Comments from Sandra Young and the following individuals offering late testimony in support: Jasmine Pontilla Stave, Troy Ballard, Teatua Here Teiti Gerlach, Tanya Smith Johnson, and Anne Freed. That's all the submitted testimony we've received on this measure. Members, are there any questions? Okay, seeing none, I have a question for the Department of Health.
Yes, Chair.
I see the Attorney General's office submitted testimony that does not, in my mind, really elaborate to the specific concerns that they articulated in the language. Are there some specific examples you can provide to justify the creation of the task force, as opposed to just trying to work the language out to address some of the issues indicated in the testimony?
So I think I can answer that in three ways. So in one way I can answer it is operationally. So the Department of Health Office of Vital Records has a ministerial function to process requests in good standing just by weighing the documentary evidence. So without weighing in on whether this is beneficial public policy or not, I can probably with great confidence right now tell you that we would need, if this were enacted as originally drafted, the department would probably request a effective date of 1/1/22 in order to prepare just operationally for this. That's with my vital records hat on as the acting state registrar. As the policy chief, the department is willing to take a stand on the merits of this as a significant public policy conversation. And there are opportunities being left on the table identified by Ms. Lockwood and the Attorney General, for example, male-male non-gestational couples, as well as a general desire to do this once well and look at other model law. We've scanned the model law from other states, and for whatever reason, they have chosen not to cross out paternity and replace with parentage. We need a little more time to look into the more unintended consequences, but unfortunately, I have to defer to the Department of the Attorney General for a more formal legal analysis. What I can say is, again, the department as a piece of public policy supports the intent. We see this as social justice and equity for all loving, responsible parents willing to step up to the plate. We need more of that in society. And if the process moves forward, we will, in the executive branch, look a little closer at what this all means from a legal and operational perspective. We hope we end up with a task force no matter what, but we have some concerns that we have expressed about the draft as written. In addition to defects that might be remedied prior to conference, and potentially bringing in other, for example, male-male gestational couples who are left out of this, that process would have to take its course. So we just think that the task force, although it is disappointing for couples who are living this painful reality right now, is the most responsible and comprehensive public policy response to this very important issue.
Thank you. Members, any other questions? Okay, seeing none, we're going to move on to the next item on the agenda, HB 33.
Oh, sorry, Chair.
Oh, go ahead, Senator Favela.
Yeah, I'm sorry, I get hard time. So, I just want, I guess oh, shucks. Sorry, I don't know what's happening. I'm doing the phone, that's why, sorry, Chair. I just got a question, to, I guess, the person I was talking before. I recall, my sister, them, when they gave birth and when they gave the parent, and it's because when they give the name, whether it's a male or female or both female, is that still a difficult task to do at that level if the person choose to put two females or two males? I mean, is that a possibility, or that's the reason why we're working on this bill?
Senator, if I understand the question, let me repeat the question as the way I understand it. Let me know if I'm getting you. In terms of establishing paternity, meaning a legal, financial, fiduciary responsibility for the care of a child, can same-sex couples apply as easily as heterosexual couples? No. We have decades of policies built around the concept of paternity that were intended to make sure things like child support weren't lost in the shuffle. So paternity is a very specific term, and I don't want to go too far in this because I'm not an attorney, I'm not legally trained. But there should be a re-examination of what happens when we cross out the word paternity and replace it, and we do not know the impacts of that. Can same-sex couple marry? Yes, of course, we know that's all in the books. Are there reciprocal beneficiary relationships that can be entered into, which is I wouldn't call it a loophole, but it's an alternate way of establishing a legal relationship between two individuals. That is a different process that is not necessarily as straightforward as voluntary establishment of paternity, which is the concept that this bill seeks to amend. So it's easy if you were from hundreds of years or centuries, millennia of male, female, legally married couples. That is what the standard is based on. That is the norm. And there are certainly other ways to achieve reciprocal beneficiary status as one example, but it is not as straightforward as voluntary establishment of paternity.
So basically, if they, even if they adopt, only one going to have parental rights and the other one not. That's what you're saying?
So that's a little different. Some of the examples that testifiers talked about today, like Ms. Ito, were planning to give birth or planning to have a surrogate. Adoption is its own other issue. Again, if you have a father willing to say, I am legally responsible, but they're not married or he's not in the picture, for example, that male may sign may establish his voluntary establishment of paternity. Adoptions are different. We would need a court order saying, okay, you two individuals are now the parents, and that court order is sufficient for the Department of Health to update vital records, for example, to reflect that legal status of parenthood. And that is why I think we have heard from other testifiers today, uniform parentage is a very complex issue with a lot of different permutations. And although we have some very, we've heard experiences that tug at the heartstrings. These are families that through no fault of their own have had to pay way more than other couples have had to. But we do think that in terms of public administration and the way we write laws and how we want to do the most good for everybody, that taking a step back with the task force is the the best bet here.
Okay, sorry, Chair. The only reason why I'm saying, I mean, I haven't been listening to most of the conversations that have been happening, but with a task force, and that's what I think Mike was talking about. If we have a task force and the task force doesn't relate to the people that is involved, what does the task force really do going forward?
Well, thank you for that question. I concur with Mr. Golahue's suggestion that LGBTQ, whoever has a dog, and I shouldn't say dog, whoever has an interest in being a beneficiary of amended policy, be at the table. The Department of Health subscribes to this, the thought that nothing about us without us. We can't sit back and say, well, we know what they're going through. So I wholeheartedly agree with Mr. Golahue that, you're at the table or you're on the menu or you'll be forgotten. Absolutely, they need to be, whoever is interested in being a part of the solution needs to be at the table so that we can learn from the wisdom of their experience. That said, the department, if we are selected to chair this task force, requests that participants be familiar with amending statute. Again, we support the intent. We do not, aside from people saying this is a good idea and cheering us on, thank you for that, but we need to roll up our sleeves and figure out how to amend statute, how to do conforming amendments and all the legalese so that we come with a bill that will meet everybody's needs and not, suffer some legal defect. So we are looking for more than just enthusiasm. We need people who know how to write laws in a fair manner, in a consistent manner. And we are completely open to input as to who that may be. So testimony from Ms. Ito or the Hawaii women's lawyers, Ms. Lockwood from Family Court, from Affirm, from the Democratic LGBTQ caucus. They're all welcome voices. We hope that we also have folks who know how to amend law and know this public policy process at the table as well.
Good, thank you, Chair. Thank you.
Members, any other questions?
Chair.
Senator Moriwaki.
Just to follow up on that question, because I think it's important as you look at the membership on the task force, it does say task force, any other member as recommended by the task force. I wonder if that's sufficient enough to get, and you did have a three firm, I don't know what you name, how you say that, but you've got one organization, but as Lauren said, do we have enough representation there and maybe some language in there that affords that?
Hi, Senator.
Let me respond to that in 2 points. The first is we want a manageable task force. If we have more than 10, it's going to get bogged down.
I understand. Yeah.
The second point is, we would be definitely open to general language, or accept recommendations from ACLU, Democratic LGBTQ caucus. I just don't know who has that right mix of policy making and advocacy. And so we're definitely open to those suggestions. And if we want to codify in statute, session law, or whatever, who might be able to make those recommendations, that's fine. But I do urge, as many of us on this call are familiar, if we have a working group with 15, 25 people, that's going to be very, very difficult to manage, unnecessarily difficult.
I guess what's not in the bill, and maybe that's kind of what you're saying, Lauren, is that we've got a task force, and they're mostly the departments and people who know how to make the law, but also there's nothing that says and getting input from the affected community or something like that because it just says shall the task force will add other members, but it's not clear that the kinds of concerns that came up on this measure today.
So two quick responses, because I know the chair's under a timetable. Yeah, we're open to, I would say my first recommendation is to clearly establish the goal of the bill. if the goal is to make sure that all families, regardless of gender identification, chromosome combination, whatever it is, if we could find a succinct way to describe the goal of this bill, which is to the Department of Health is about fairness. Why should a male, female, traditional couple be able to, quote, sign on the dotted line, and pardon my glibness, whereas others we've heard, again, heart-wrenching testimony of spending upwards of $20,000 or having to go to the mainland. And what about folks who can't afford that? So if we can come up with a succinct sentence or two about the goals of a comprehensive uniform parentage reform recommendation, I think that would take us a long way there. And then subsequently, if we want to identify more specific stakeholder groups, that I'm fine with that too. Again, our hope is that they have policymaking experience, because it's more than just this is a good idea. It's okay, we really got to figure out what the legal terms are and what those conforming amendments are. That's the real work. I think we are beyond the stage of this is the right idea at the right time.
Thank you, Chair.
Okay, members, any other questions? Okay, we're going to move to the last item on the agenda, HB 334 HD1, relating to operating a vehicle under the influence of an intoxicant. This establishes a state drug and alcohol toxicology testing laboratory special fund to be administered by the Department of Health. It deposits into the special fund fines imposed on offenders convicted of certain offenses involving operation of a vehicle under the influence of an intoxicant. First, we have testifying in support, the Department of Prosecuting Attorney, City and County of Honolulu, Tricia Nakamatsu. Okay, we're going to move to the Honolulu Police Department in support.
Good afternoon, Chair, members of the committee. Major Calvin Tong with the Honolulu Police Department. We stand in support of this bill on our testimony.
Thank you very much. Department of Health, Environmental Health Administration in support. Okay, Department of Budget and Finance offering comments. Okay, we're going to move to the Department of Prosecuting Attorney, Maui County in support.
Not available.
County of Kauai, Office of the Prosecuting Attorney in support. And Hawaii Police Department in support. Oh, I'm sorry. I see, it looks like those are all the individuals submitting testimony who indicated they would be present. Is there anyone else on the conference who would like to testify on this measure, HB 334? Okay, seeing none, noting for the record, testimony all in support from also the Maui Police Department, the Strategic Highway Safety Plan, Mothers Against Drunk Driving, Clifford Wong, Taryn Adams Leon, and late testimony from the Hawaii Department of Transportation. That's all the submitted testimony we've received. Members, are there any questions? Okay, seeing none, we are going to recess briefly for decision making. Recess. Okay, we're going to reconvene for decision making on this Wednesday, March 17th, 1 p.m. Health Committee agenda. First item on the agenda is HB 723 HD1 relating to pandemic response. All supportive testimony, so I'm going to recommend, we have some non-substantive technical amendments to make to the bill. And I'm going to recommend that we amend this bill to make this measure effective upon approval. Members, any discussion? Okay, seeing none, Vice Chair, HB 723 HD1 passing with amendments. Chair votes aye.
Chair votes aye. Vice Chair votes aye. Senator Moriwaki?
Aye.
Senator San Buenaventura?
Aye.
Senator Fafella?
Aye.
Chair, your recommendation is adopted.
Thank you very much. Next measure, HB 302 HD1, relating to APRN certifications of disability. I'm going to recommend that we adopt the Hawaii State Center for Nursing's amendments and make this measure effective upon approval. Any discussion? Okay, seeing none. Vice Chair, HB 302 HD1, passing with amendments. Chair votes aye.
Vice Chair votes aye. Senator Moriwaki.
Aye.
Senator San Buenaventura.
Aye.
Senator Favela.
Aye.
Chair, your recommendation's adopted.
Thank you very much. Next measure, HB 987, relating to hearing and vision program. I'm going to recommend that we make technical, non-substantive amendments and amend this bill so that it becomes effective upon approval. Any discussion? Okay, Vice Chair, HB 987 HD1, passing with amendments. Chair votes aye.
Vice Chair votes aye. Of the members on the call, any with reservations or opposition? If not, cast an aye vote for all members. Chair, your recommendation's adopted.
Thank you very much. Next measure, HB 986 HD1, relating to newborn hearing screening. I'm going to recommend that we make technical, non-substantive amendments to the bill and make it effective upon approval. Any discussion? Okay, seeing none, Vice Chair, HB 986 HD1, passing with amendments. Chair votes aye.
Vice Chair votes aye. Of the other three members on the call, any objections or reservations? If not, aye votes all around. Measures adopted, Chair.
Thank you very much. On the next measure, HB 1096 HD2. This is our second hearing on this measure. We had a long discussion on the Senate version as well. I think there's still some work that needs to be done on this measure. So I'm going to recommend that we defer decision-making on this bill until Monday, March 22nd at 1 p.m. Monday, March 22nd at 1 p.m. And the last measure on the agenda, HB 334 HD1. This is relating to State Drug and Alcohol Toxicity Testing Laboratory Special Fund. I'm going to recommend that we move this measure out with technical, non-substantive amendments. Any discussion? Okay, seeing none, Vice Chair, HB 334 HD1, passing with amendments. Chair votes aye.
Vice Chair votes aye. Of the other three members on the call, any objections or reservations? If not, aye votes all around. Chair, your recommendation's adopted.
Thank you very much, members. We are adjourned.